Hi, my name is Steve Cortes at the Cortes Law Firm. This is the third of 6 quick educational videos in a series that we're doing on estate planning. If you missed the first 2 videos, then you can use the link below to watch them. And if you have any questions along the way, please don't hesitate to give me a call. Our topic today is the Oklahoma probate process. The Oklahoma probate process can be confusing and frustrating for many people. The probate process that I'll describe today can take 6 to 10 months on average. However, we regularly have probates that last over a year or longer when the heirs are fighting amongst themselves. Now, an Oklahoma probate begins by filing a petition requesting that someone be named as a personal representative of the estate and that the court determine the deceased person's heirs. A notice of hearing must be given to all interested parties by U.S. mail and by publication in a local newspaper that qualifies for legal notices. Now, at the initial hearing, the court will issue what's called letters of administration appointing a personal representative. After the initial hearing, notice to creditors must be given to all known creditors by U.S. mail and again by publication in a local newspaper that is qualified to print legal notices. If creditors come forward, then the personal representative must determine if the claim is legitimate, and if so, then request an order from the court allowing payment of that claim. Once the creditor claim is paid, then the personal representative must get a release of claim from the creditor and make certain it is filed with the court. The next step is for the personal representative to conduct an inventory and appraisal of all assets in the estate and submit it to the court for approval. Once the court approves the inventory, then the personal representative must make an application for a final hearing and distribution of assets to all the heirs. So, as you can see, each of these steps requires notice to heirs and all interested parties by either mailing or publication or both. Now, after the court issues its final order, the personal representative's job is not necessarily over. They still need to distribute the assets per the court's order and make sure all the expenses have been paid. Now, I just went over the steps generally, but as you can see, the probate process is time-consuming and can be expensive, especially if the family and the heirs are fighting over the assets. Now, it is possible to avoid probate by distributing assets with certain tools, such as joint tenancy with right of survivorship, pay-on-death designations, and transfer-on-death designations. While these are important tools, they can have unintended consequences. I always ask couples with kids, do you want your kids to have your assets, or do you want your wife's new husband's kids to have your assets? Think about that question again. Do you want your kids to have your assets, or do you want your wife's new husband's kids to have your assets? That one question illustrates why proper estate planning is so important. A revocable living trust can help you distribute your assets the way you want them distributed and help your family avoid a lengthy and expensive probate. Well, that's all for today, but please do not hesitate to call if you have any questions, and watch out for our next video, which is about the essential documents that are necessary for incapacity. If you have any questions, then please give us a call. Thanks, and we'll see you next time.